you so much for joining us for this fireside chat. We unfortunately don't have like a fireplace here, which would have made it a bit more interesting, but thank you so much for joining us. We have the pleasure of having two distinguished, wonderful speakers. Let me introduce you to them, but before that, let me introduce myself. My name is Roberto González, and I am the Chief Advocacy Officer at the Human Rights Foundation. I co-lead the legal and policy team along with my colleague Javier, who may be in the audience. And our wonderful speakers, let me start introducing Dr. Tatyana Eatwell. Welcome.
Thank you.
Dr. Eatwell is an international human rights lawyer at Doughty Street Chambers in London. She has acted in several cases of arbitrary detention, targeting and harassment of journalists and human rights defenders by state and non-state actors. Her cases include those of Jimmy Lai, whose son, Sebastian, was on the stage moments ago, basically. For those of you who are not familiar with the case of Jimmy Lai, Jimmy was the founder of what was back then the biggest newspaper in Hong Kong, Apple Daily. And Dr. Eatwell has also represented the case of Nazanin Zaharia Ratcliffe, which we have in the audience. Thank you for being here, who is a British Iranian national, arbitrarily detained in Iran from 2016 to 2022. Welcome. We are also very honored to have Ms. Julie Sunday, who is the Assistant Deputy Minister and Senior Official for Hostage Affairs at Global Affairs Canada, which is the Ministry of Foreign Affairs in Canada. Ms. Sunday is responsible for advancing the Canada-led declaration against arbitrary detention in state-to-state relations. She was also named Canada's first official for hostage affairs in October of last year and has been engaging diplomatically to support the release of hostages abroad. Thank you for being here. Welcome both. Let me start by setting the stage for our conversation. So, authoritarian regimes, unfortunately, as most of you can imagine, lack judicial independence. The result of this is that dissidents, activists, journalists can be easily targeted and prosecuted within those systems. They don't have legal recourse. They have little to do when it comes to trying to advocate for their cause or trying to prove their innocence. What happens to those folks once they have lost all hope within their systems? There are several things that can happen at an international level when it comes to either civil society in the form of human rights organizations that can advocate for them, or law firms, like in the case of Dr. Eatwell, or democratic governments can also play a role in trying to advocate openly or discreetly via diplomatic means to try to release these folks. Obviously, when it comes to states, they are limited by mandates as to whom they can try to help. Most of the times, these are citizens or dual citizens or legal permanent residents. When it comes to the international arena, in case some of you folks are not too familiar with how things work when it comes to international human rights law, there are several mechanisms that people can, or law firms can use to advocate on behalf of arbitrarily detained individuals. Most regions of the world have their own human rights protection system. In the American level, in the Americas, there's the Inter-American Human Rights Protection System. It has its own commission and its own court, which is based in Costa Rica. In Europe, they have the European Court and the Commission. They also have the Council of Europe with certain mechanisms. Africa has something similar with its own commission and court. And Asia, unfortunately, has none, as you can expect. And when it comes to the whole world at global level, there's what is called the Universal Human Rights Protection System, which is the mechanisms of the UN, which its most important body is the Human Rights Council, And there are other mechanisms like special rapporteurs, groups of experts, etc., etc., etc. I would like to start this conversation with Dr. Eatwell. So you have been defending Jimmy Lai. Could you please tell us a bit about what happened domestically with the case of Jimmy? How long has he been held in prison? What motivated you, forced you to try to take his case to an international platform?
Sure. So thank you very much for having me here. Please call me Tatyana. I don't need to use Dr. Eatwell, it's fine. Thank you, everyone, for being here. So if you were all in the main theatre this morning, then you will know that Jimmy Lai is one of the most prominent pro-democracy campaigners in Hong Kong. And he was the owner and publisher of Apple Daily, the largest pro-democratic Chinese language newspaper there. He was first arrested in August 2020 under ordinary, should we say, laws with respect to his peaceful participation in protest in Hong Kong from 2019 to 2020. And then he was later arrested under the national security law, and he was placed in custody, remanded into custody in December 2020 under the national security law for alleged collusion with foreign forces. And he has been in prison since then, so he's now in his 4th year of imprisonment. And during that time, he has been prosecuted under public order law for participating in peaceful protest and received lengthy sentences of imprisonment. Sebastian this morning gave an example of that. He attended a Tiananmen Square vigil on the 4th of June. It's the anniversary today, so quite poignant that we're speaking about Jimmy today and these issues. He said a prayer, he lit a candle, and he was prosecuted and convicted and sentenced to 13 months imprisonment for entirely peaceful protest. And he has faced 4 domestic prosecutions in that respect. He has also been targeted and prosecuted for fraud, which arises out of a landlord and tenant dispute. It really is as benign as that. It was a dispute between the commercial landlord of the Apple Daily offices about subletting a portion of the office. And for that, he has, we think, on analysis, the first individual to have been prosecuted using criminal laws of fraud for such a dispute in Hong Kong and any common law system, and has been sentenced to 5 years and 9 months imprisonment. And I raise that because it's a really important factor in terms of the methodologies used that we see in patterns around the world in terms of the targeting of prominent critics of governments or human rights defenders, journalists, not just with national security laws, and Jimmy Lai is currently facing trial under national security law, but also with money laundering, tax evasion, these kind of financial offenses in order to discredit the person and tarnish their reputation. And it's a really effective way for the regime to discourage other states or organizations from speaking out on behalf of that individual because they try to tarnish their reputation in that way. And we're seeing it in Guatemala with Jose Zamora, who's the owner of the publication there. He, as well, has been targeted with these kinds of offenses. So Jimmy is now undergoing national security law trial in Hong Kong. The evidence is still in train, the prosecution case is in train, and it's abundantly clear that from the prosecution's case that what he is being prosecuted for is conspiracy to commit journalism, conspiracy to talk about politics and democracy with politicians, and conspiracy to talk about accountability for human rights violations with human rights organizations. So what is clear ever since, well, it was becoming clear before the enactment of the national security law in Hong Kong that is now in force, that it was becoming clear that the rule of law was breaking down in Hong Kong. Rule of law used to be Hong Kong's USP. It's what they thrived on. It's why financial businesses and services and legal services were in Hong Kong. It was a major arbitration hub. It's abundantly clear that Hong Kong is no longer rule of law compliant, as you were saying, in many of these cases. So really, where is there the thin veil, the pretense of a trial going on? The outcome of that trial is predetermined, not least because the charge with which Jimmy Lai is being subjected to is so broad. And you look at the prosecution case, they are saying collusion with foreign forces means meeting with Nancy Pelosi and discussing politics with one of the most senior Democratic politicians in the United States of America. So it is wholly farcical, but nevertheless terrifying and has serious repercussions because if convicted, he faces the rest of his life in prison.
And he's how old now, if I may?
He's now 76 years old. So where you're dealing in this case, as we are with Hong Kong, with a non-rule of law compliant jurisdiction, the resolution is by and large not going to be through the courts, although there may be situations where there is seemingly a resolution through the courts, or some face-saving solution to the issue that someone might get clemency after conviction. As with the case of Matthew Hedges, who was detained in UAE. And the resolution of that is often political, diplomatic, and through international, and going to international mechanisms is part and parcel of and it's in the case of British citizens, unfortunately, of which Jimmy Lai is British, and I say unfortunately because part of the struggle for British citizens detained abroad is persuading their own government that they are arbitrarily detained, and you use international mechanisms like the special procedures with the Human Rights Council, human rights experts, the Working Group on Arbitrary Detention, in order to have that expert sort of validation of your case that you are being arbitrarily detained, and that's persuading your own government that they should be speaking out, making representations on your part. And B, to rally the international community around the cause, because it's only really when authoritarian regimes find it more costly, either because they suffer diplomatically or in trade, or the individuals may be subjected to sanction if appropriate, that they will stop the practice. As my dear client friend Richard Ratcliffe, who's here, always said, you have to be a constant irritation. The governments will only shift if you are a constant irritation. They want to get rid of you. They want to get rid of you by making the problem go away. What's the problem? They're the problem. They need to release the individual. And happily, Richard was successful in his quest in that respect.
Correct. Thank you so much. You touched on a topic which is very important, and you mentioned diplomatic efforts. Governments, of course, and states have a big role to play when it comes to trying to use diplomacy to release some of these individuals, detain some of these regimes. I would like to now refer to Assistant Deputy Minister Sunday, I can call her Julie from now on, if I may. I know that Canada launched an initiative recently when it comes to it's against arbitrary detention when it comes to state-to-state relationships to, in this case, try to deter the hostage-taking of individuals as a sort of political leverage, which unfortunately is a practice, a heinous practice that has been going on for quite a few years, and it's only increasing. Could you please talk to us a bit about that initiative and why Canada decided to jump on this space to basically lead, to some extent, these conversations?
Thanks. I think every country has an experience with this issue. And I think, why this declaration matters so much is, we're seeing an increasingly fractured world. It is very complicated geopolitically. We're in a time of great power conflict in a way we haven't seen in a while. And basically, what we've noted is that anyone living, working, traveling abroad could be subject to this really, reprehensible practice. The Declaration Against Arbitrary Detention in State-to-State Relations is really built around, increasing global solidarity for what seems like a pretty obvious thing, which is that our citizens shouldn't be used as bargaining chips. There are 77 countries now who are signatories, which we're really pleased with. I have certainly noted in the past couple of years increasing interest from across the globe in terms of sort of engaging with the initiative, signing on, and I think this is a recognition that there's strength in numbers. You don't want to be isolated when this happens. You want 77 other countries who agree with you that this isn't a legitimate tool of statecraft, and that is unfortunately how it has been used. So this is an important initiative which I would sort of put in the basket of working to deter the practice and raising the stakes, the reputational stakes, certainly for perpetrating states. But there's a lot more to do, and I'm happy to talk more about that as we go on.
When it comes to deterrence, which is obviously a very important topic, are there any tools to be developed based on the declaration? What can governments, and specifically Canada, can do in these cases that you can tell us about? Generally speaking, what are the tools at Canada's government disposal, for example, when it comes to trying to deter these practices?
So, deterring partially is profiling this, right? Is saying, looking at these cases, and I would say it's kind of an evolution of thinking. So yes, these are human rights violations, and there's established principles in the international legal space that arbitrary detention is a human rights violation. However, when a state takes a citizen for coercive purposes, for coercive diplomatic purposes, it engages something else. It engages the state, who then has a right to protect their citizen. And I think this is where we need to understand more what that international legal space is and where there may be gaps that we can address it. So, the mechanisms there, and again, this is arbitrary detention is prohibited very clearly in the 1948 Declaration and onward. There are, of course, as Tatyana mentioned, really significant the UN Human Rights Council, the special rapporteurs, the UN Working Group on Arbitrary Detention, who do really important work reporting on this, responding on individual cases, engaging with states, et cetera. But there is no enforcement in those bodies. And this is, clearly there is an accountability gap. And it's something that is quite important. There are other gaps. We talked yesterday about the Vienna Convention, right? And looking at how it is silent in the case of dual nationals. There is a protection gap there in terms of how those cases are treated. But really, our concern is now looking at, okay, how do we address this? And this is why Canada has recently struck an independent international legal panel with 7 very esteemed jurists from across the globe. So we have, it's chaired by a Canadian Sierra Leonean, Charles Jallow, who's also on the International Law Commission, and then a number of other, very impressive individuals. And we've said, please have a look at this. They are reviewing what's in place in terms of laws, norms, processes, protocols, and then advising, and they'll provide their recommendations in a year. You know, there are sort of, you know, there's a trail of instruments you can look at. Like, you know, yesterday we spoke also about the Convention on Hostages, right? I mean, this is an established convention. However, it's focused on individuals in terms of who it engages. And it's predominantly non-state actors. I mean, that exists really in the conventions around counterterrorism, right? So what do we do now that we have states behaving badly? And this is where we're looking at what could the recommendations be. You know, the declaration is a starting point, and it could reach a critical mass of endorsements that would be incredibly valuable in terms of looking at what the impact is on international customary law, and that this be a prohibition in that context, or, you know, do we need additional norm-setting initiatives, and are they going to make recommendations around, you know, pursuing possible conventions, et cetera? So, I mean, this is a long-term enterprise, as you know. You work in this space, but we think it's a worthwhile effort.
Thank you so much for that. One thing you mentioned, which is something we have experienced as well at HRF, is the issue of lack of enforcement when it comes to most things related to international human rights law. For those of you who don't practice in that space, any submission, processes, appeals to most international mechanisms are costly. They take a lot of time. It is difficult to get in touch with the stakeholders in those spaces. I can give you a couple of examples. I mean, the European Court of Human Rights and the Inter-American Court of Human Rights, they take 5, in some cases, 10 years to issue sentences about some of the few cases that they actually take on. Their backlog, it's like thousands of cases. And kind of something similar happens with special rapporteurs, etc. And it's a compounding issue in the sense that on the one hand, they have little resources. They barely have staff. Some mechanisms have half a staffer assigned to them. So it's not just about, part of the problem is the lack of resources on their end and the massive amount of work that they receive or they should try to address. But despite, obviously, these challenges, international mechanisms are still a resource that most practitioners use. This kind of tough question goes to Tatyana, which is a question that I've asked myself many times. Despite all the challenges that, you know, trying to get an opinion out of the working group on arbitrary detention or any court or other mechanism, where's the value in that you see?
So yes, there are no international human rights mechanism is perfect, but also just sort of to take us back, I mean, it's difficult to be general about this actually, right, because each individual's case is different, and Ambassador Carsten said that yesterday. You know, you've seen one case. There is no formula that can be applied generally in an individual's case. The value of these mechanisms, so certainly if you are in a Council of Europe state, we heard about arbitrary detention in Azerbaijan this morning. The value of the European Court of Human Rights is it does have binding decisions on states. It's connected to the Council of Europe, and it can give provisional measures where there is an imminent risk of torture or risk to life. And so whereas it may be slow in some cases to judgment, ultimately there are these provisions available, and it's connected within the Council of Europe, and that is important too, because the value of this mechanism is not just in getting the ruling, it's how you use them. And so when you approach these cases, not particularly, you know, not necessarily with Council of Europe states, but them included, but particularly states where your only mechanism available is the UN Human Rights Council. You're right, you know, an opinion of the working group cannot enforce it. It's sort of not a hard law mechanism. But so it's how you use it. And you use it within your discussions with other governments, with key interlocutor states who may have influence on the government that is detaining your client. And they may not be democratic states that you're talking to. And even undemocratic states care about their reputation in the UN. To take Jimmy Lai's case, for example, China has really shown its cards that it really cares about hearing criticism of their suppression of the right to freedom of expression and peaceful assembly in Jimmy Lai's case. They have outwardly shown it by accusing us, the lawyers, in the Council of Europe, in the Palais des Nations, of committing criminal offences for raising human rights concerns. They have really shown it in an official communication to the special procedures in his case, where the special rapporteurs asked the question whether raising human rights concerns would be a violation of the national security law. Now, one would expect any rule of law compliant state to come back and say, of course not. You know, and we're a member of, you know, we're one of the P5, we're a founding member of the United Nations. Principle of the purposes of the United Nations is to promote protection of human rights. No. What was their answer? Well, it depends. So the equivocal answer in itself is reprisal. But whereas the delegation is very open and blatant in its upset about our raising this case in the Council, it does show that real care about the reputation on the international stage. And so the value of using these mechanisms is not just for that validation, for the person to have experts say, you know, yes, we've looked at this and you are being arbitrarily detained. No matter what because authoritarian governments will say to any state, so say Lord Cameron, Foreign Secretary of the United Kingdom, he has called for Jimmy Lai's release on the 17th of December and repeatedly says it. Calls for it. And the response is, you know, don't interfere in our internal affairs, we're conducting a trial. And non-rule of law compliant regimes will use the language of law in order to justify what they are doing. They will say, we're going through a trial process. They will use general principles of international law about non-intervention in internal affairs of other states. They will completely ignore the fundamental violations of rights. But the value of these mechanisms is you have there an expert opinion or a judgment of a court which says, no, this is a violation of rights. And you are part and parcel of this international system, and you need to respect this. And then other states, the value of it is that other states can then, and governments can then also look to it and say, we have, you know, the working group on arbitrary detention opinion has found that. And we are deeply concerned on this basis as well. So they sort of embolden governments who may be hesitant to intervene and make representations either about their own citizens or about other citizens on point of principle. And I would say that their governments do intervene on behalf of non-intervene citizens. And I'm not just saying this because Julie is here, but Canada is a government that does speak out about non-citizens, where it's on points of principle, when people are being detained because of exercising their right to freedom of expression, etc. And to get that chorus in the Human Rights Council and within the UN is really valuable, because even authoritarian states care, really do care, yeah.
I completely agree. I think it elevates the political cost to them of keeping those folks in prison. And also, and just to add a bit to that, I think it's also a form of historical record, in my view, that perhaps in a future transition to democracy, there's going to be a record that this happened, that what happened to this individual or that individual was wrong, and there may be a form of redress available to them after, you know, well, when they become democratic. But one question for Julie is, we've talked about, you know, the role of civil society, but what's the importance from the perspective of the government, of the Canadian government, of different stakeholders? How can other stakeholders help your efforts, like civil society, the survivors, obviously, of these practice, their relatives? How do you not utilize them, but how do you make them part of these processes, of your efforts?
Thanks. I think that's a great question, because, and this is a really unique space, because I actually, I've been so impressed with the work of civil society, also with the advocacy that victims and their families have engaged in. I think it's unfortunate that families have to advocate to the extent that they do. As government, our job is to try to make sure that our system works and responds well in all cases. And so, it is all about raising the costs for perpetrators and, raising the stakes. And, governments can do that. I think it's an important role, and I think it's something, that we saw. We had a high-level dialogue on the margins of the UN General Assembly in September. That was really powerful. Jason was there, Michael Kovrig was there, and it was co-hosted by Malawi, Costa Rica, Canada, and the United States, and the foreign ministers were all there. And I think, it really brings to the fore the importance, the ultimate objective of this is, raise awareness, deter, but also have more effective ways to respond. And so, in a perfect world, when a citizen in Costa Rica is taken, or Argentina, we in Canada treat that arbitrary detention for state-to-state leverage as though a Canadian has been taken, and that we are all kind of have that relationship to be able to do that and use every tool at our disposal, which can be, broad. It can be sanctions or, other kind of political dialogues. It can be, there's a broad range of things that governments can bring to bear on these cases and do. But you're in much better company when you're not alone, when you're not being isolated in these kind of, bilateral dynamics. And so civil society is around that because unfortunately these are diplomatic leverage cases. It is inevitably going to bring the state in. The state has to be there. But civil society is able to kind of, bring other elements to the conversation, raise awareness so that it isn't, all kind of hidden away. Also, I would say we really need good academic research. The more we have an evidence base on this, the more important it is. Yesterday, we were in a discussion around, incentivizing or not incentivizing. Like, we have to look at that as a data point. I think, ultimately, the gauge of success has to be resolving cases and preventing further cases. So I think there's a broad range, but my hope is that as the system works together, and we don't always agree, but that the discussions are rich and that they, they're mutually enforcing objectives. And yes, like I will say, I just want to flag this because countries are starting to talk a lot more about this and how they can help each other. It's hard. Like, I will tell you, these are your most sensitive consular cases. The last thing you want to do, like, I'm the head of consular for Canada as well, and the last thing you want to do is make something worse. And so you proceed kind of carefully around that. But when it's clear that the solutions aren't consular, that's when the dialogue has to sort of expand. And that is where I do see a lot of sort of relationships of trust developing around states who are genuinely concerned about this. And over time, that will just get stronger. Yeah.
Very interesting. When it comes to collective action by states, do you think states are better positioned to act individually or collectively?
My personal view is collective. That's the principle behind the declaration, is that this has to be, a collective action. it is a breakdown. I mean, we talked about human rights. Yes, these are human rights issues. These are human rights cases, and we heard that yesterday, and I do not diminish that in any regard. But these are international security issues as well. These types of detentions erode predictability in the international system. They erode trust between states. They are, they are destabilizing. And the only way to respond effectively to that is not to be isolated in a bilateral, sort of dynamic where you're kind of behind closed doors trying to figure this out by yourself. That's a terrible position to be in. I know we have been in that, and we chose to engage much more broadly with much greater effect. And so that said, I will say, I mean, it is case by case. You have to kind of look at each of these very individually, but collective action is really key, and that's not just governments, but also civil society. So,
from the perspective of civil society, and I want to play devil's advocate to some extent. I mean, if you think about collective action, one could argue that it perhaps would incentivize, because you get more of what you incentivize, correct? So if you create a sort of collective platform via which authoritarian regimes know that they can engage with a certain set of countries who are able to, I don't know, engage in negotiations. And again, I'm trying to play devil's advocate here. What do you think the incentive system would be for that sort of coalition group?
I think, I mean,
let me try to expand on the question. I am originally from Guatemala, and there's a reason why Guatemalans don't get kidnapped or taken hostage anywhere in the world, because there's nothing to be gained. There's no leverage. There's no resources. Guatemala is nothing of importance at international level, and there's a reason why Canadians and Americans and people from the UK get taken hostage. That's reality. We deal with a system of incentives. So don't you think that perhaps that system, or what type of incentives would that system need in order not to incentivize precisely the sort of conduct that it's trying to deter?
Yeah, I mean, I think it's interesting because I actually, I don't totally accept that premise that this wouldn't happen to some. I think it can happen in different countries for different reasons. Peacekeeping troops in one country in Africa who got pulled into another. Like there are many different areas where something is happening for leverage, and as the minister from Costa Rica emphasized in September, I mean, rule of law matters. It matters in particular to small countries who aren't necessarily linked up in alliances in the same way others are, and this is crucial, right? Like knowing that you're not alone if your Malawi and your citizen is taken for leverage, that you can call up others across the globe to help with that. I think that is maybe the communication challenge we have to kind of work on, and I also think this is one of why why our legal panel is representative of every continent in the world, to have those regional perspectives, but also why we need to be having discussions. So for example, we're having some really rich discussions with the OAS now, and there are some really interesting examples where trying to understand what this means from a regional perspective as a way of ensuring this is a global norm that is widely applicable to everybody is, I think, crucial. So there's not just a Western issue,
Correct, agreed. Yeah, and that was a difficult question on purpose. Obviously, the flip side of that is that any decent government should do whatever it takes to try to get their citizens out of harm's way. And incentives sometimes cannot be controlled, because some governments, as we have witnessed, Russia, China, they don't work too well with incentives. So it's not like you can predict how they're going to react or what incentivizes them to some extent. Now, Tatyana, how has been the dynamic with, if you could speak about that, with the British government when it comes to the case of Jimmy? Do you think they have done enough? Do you think they should try to do more? Have they been receptive to your requests to help more the case of Jimmy?
So with Jimmy Lai's case, as with many cases of British nationals either taken hostage or arbitrarily detained abroad, often families feel like, at least in the first stages, they're fighting on two fronts. They have a fight with the government that's taken their loved one, and they have a fight with the UK government. Why is that? Well, the Foreign Office is rather reticent in its policy in terms of making representations on behalf of its citizens. Firstly, they're quite conservative. Secondly, they don't have a special envoy or someone who is designated to deal with this within the Foreign Office or in a separate department. So you're dealing with desks within the Foreign Office for particular regions where civil servants rotate quite often, and there's a real lack of institutional memory. So people are often dealing with this as a blank slate. They haven't come across these cases before. And thirdly, we've had quite a few foreign secretaries recently. So we've had, I don't know, Nazanin is the best one, number 6 now, maybe. Yeah. And that is, there's a real lack of institutional memory there within the sort of the top person, because we don't have this special envoy model. And it also very much relies on the personality of the foreign secretary, whether or not they will look at a case and take it seriously and prioritize it. So in Jimmy Lai's case, Jimmy Lai is British. China claims him as being a Chinese national. And the UK, for some time, didn't continue to, as they did in Nazanin's case, actually, continued to use dual nationality, as they called it, although Jimmy is solely British, but because of China's claim, they use that as an excuse for, well, we're limited in what we can do. And so families really have to push, quite often have to push the British government to see beyond turning up what they see as quite a limited approach to consular assistance, where you turn up, you request it, and if you're allowed in, you check the person's okay, and you make sure they have legal representation. In Jimmy Lai's case, we're way beyond that. And in many of the cases, I mean, within a couple of weeks, you can see you are beyond that. And whether or not the person holds another passport is, in my view, irrelevant. They hold a British passport, and by that reason, the UK government has an interest in ensuring that they are treated properly, and if there is no lawful basis to their arrest and detention, they are immediately released. The problem is that the UK government is slow to get to that place. With Jimmy's case, we now are in that place. It is UK government policy that he should be immediately and unconditionally released. And the Foreign Secretary, Lord Cameron, said the same on the 17th of December, on the eve of the start of his trial, which is unusual for the UK. The UK, in Vladimir Kara-Murza's case, waited for him to be sentenced to 20 years imprisonment before they said, and sorry, I see his lawyer here, before they said he should be released. So, I mean, that is a positive move, but that is very much the Foreign Secretary, but also because there has been a rallying cry from the international community. The Canadian Parliament has passed a unanimous resolution calling for Jimmy Lai's release. The US State Department condemned his conviction for fraud and called for his release, and they have continually called for his release. The European Parliament has passed several resolutions calling for his release. And the Council of Europe has made, the EU, pardon me, has made statements also. And this came before the UK did. But we are now in a position where it's UK government policy, it's the Labour Party, the party in opposition's policy, that he must be unconditionally and immediately released. So we have that. The question is, with governments, this is great. The declaration is great. Calling for someone's release is great, right? What concrete steps are you now going to take to make it happen? And so in terms of our advocacy, we will continue to push the UK government, to speak with them, to engage them about what they are doing to secure his release, as well as working with the Human Rights Council and Special Procedures and those UN experts to keep this as a priority on the international stage as well as with the UK government.
Thank you so much. We have unfortunately run out of time.
Sorry.
This is a fireside. I wish it was a panel. But I want to, this is a difficult topic. Obviously, there's no, so far magic formulas to try to address it once and for all. It's a sort of efforts activity, and we are all learning how to deal with this phenomenon. But on a personal note, I am very glad that we have Julie's leadership in Canada, that we have Roger's leadership in the US. And also I wanted to acknowledge, the presence of some victims and survivors of these practice. Jason here in the audience, Nazanin here. I'm glad that at least there's broad consensus that this is a topic that needs to be talked about, that we need to coordinate efforts between democratic governments and civil society to try to come with ways to address this in a reasonable way, much better than what we have currently. So thank you so much, Tatyana. Thank you so much, Julie, for joining us, and thank you for joining us.